Welcome back to the House Judiciary Committee. Continuing testimony on different parts of S-109. And let's go to Heather McLean next. And this is on sex, for those following along, this is section 25.
Hello.
Oh.
I am Heather McLean, and I'm the Revenue Enhancement Director for Department for Children and Families, Family Services Division. So thank you for allowing me to come and speak to Section 25. As mentioned earlier, this language came up last year, and I was actually the one who testified then as well. So I will start by saying DCF does support the changes that were made in 2024 that remove the provision of Title 15A permitting consideration of non-payment of child support as a factor in termination of parental rights proceedings. But we also understand that there were unintended consequences of that change. So we know that there needs to be further refinement and clarity because 15A governs all adoptions, including those inside CHIN's proceedings and outside as well. So while we're normally under 33, 15A comes into play when it gets to termination of parental rights and adoption. So I wanted to give you a little bit of context about why we're here and why we're asking for this, or asked for the change last year and what we're proposing for this year to move forward, because I think the connection between child support and child welfare is likely not very well known. But historically at Family Services, when a child enters foster care, we have staff who do an assessment to determine if they have any benefits when they enter foster care, and that includes an active child support order. And if they do, we motion the court to become the obligee of that child support action so that Family Services receives those child support funds and then uses those funds to offset the cost of foster care. If a child comes into foster care and they do not have an active child support order, we do an assessment that includes a financial analysis of the family, but also other factors to determine if we should pursue going after child support once a child enters foster care. And that work has been supported by federal rules, which required us actually to at least analyze if we should pursue child support in cases where a child has been found eligible for Title 4E funding. And Title 4E is the funding that we get from the federal government that supports room and board costs for children in foster care. The thing about Title 4E is that it's a need-based program. And so in order for a child to be found eligible, their family has to meet a standard, which is the 1996 ANFC standard. So ANFC is a precursor to TANF. So what we're talking about with that population is families who are living in poverty. So in 2022, the federal government changed that rule and no longer required child welfare agencies to pursue child support for families who are eligible for Title 4E. And that really allowed agencies across the country, including ours, to be more trauma-informed and equitable in our practices. So I just want to make it clear that DCF does not use payment or non-payment of child support as a factor in whether we pursue termination of parental rights. The decisions that go into that, excuse me, are based on a parent's ability to safely care for their children and meet their basic needs. Child support work is handled separately from case planning and permanency planning. And for example, our family services workers, as they're working with families, aren't briefed on child support matters that are being pursued, if there are any being pursued. And case decisions then are based on the totality of circumstances of a family, not just an isolated factor of whether or not someone has paid child support. And I want to mention, this is child support that goes to the state, not to the other parent. So our approach is consistent with national guidance that tells us that poverty should not be the basis of separation of a child from a parent. So the reason that this came up last year is that there's been a lot of advocacy work, and that's what preceded the federal change, but there also was some media attention about this practice around the country. And so specifically, there was a story done by National Public Radio in 2023, highlighting a different state that was using failure to pay child support as a factor in pursuing terminations of parental rights. And in that story, they mentioned that there were a few other states that also allowed this practice, and Vermont was named. And again, I will note, we haven't used that provision to pursue termination of parental rights, but we realized in that scenario that we really wanted statute to align with our practice, so that it was clear that that's what our practice is, and that's what best practice is when it comes to child welfare. So in terms of a path forward, again, going back to sort of the unintended consequences of striking that language, is what we would hope to do is that if the language is restored to 15A, we would support a statutory carve-out affirming that non-payment of child support shall not be used as grounds for termination of parental rights in CHIN's proceedings initiated under Title 33. Again, that alignment between what our practice is and what the statute says is really important to us. And I think, we can't take for granted that the system will always act in a way that we intend it to, or will always be according to our best values. And so we want to make sure that the statute is matching the way that we practice and what is best practice for children and families.
Okay, great. So makes sense. Questions? Okay, Angela?
Well, I was trying to write down what you just said, but could.
It's we have it in written testimony.
Oh, great. I was like, what's that all about? And I just want to walk through like my thinking with you to make sure that, because I remember the testimony we heard, describing the unintended consequence being that payment of child support should be allowed to be considered as like a good thing. It's like, hey, so
Sure.
So this carve out that did you describe it that way? I don't want to put words in your mouth.
Yeah.
Okay.
Yes, I did. Carve.
I heard that. Sorry, but I wanted to make sure you weren't referring to the other thing. Anyway, this carve out would not affect that, correct? Because it's
Right.
getting just more specific
Yes.
and not, therefore it won't impact the proceedings that our previous witness was describing. These are very specific instances that DCF intends to affect.
Yes, that is correct. So really trying to have it apply to our cases that are initiated under Title 33, CHINs, but not anything outside of our.
Great. Okay. Thank you.
I think you've answered this, but I sort of lost it in all of the other things you were talking about.
Sure.
So we heard testimony from another witness that DCF isn't involved at all in this. And I guess can you just what statute are you utilizing this language in? So that I can go read it and I'll understand it. But I just am trying to understand why we need to carve out here if what we heard was DCF isn't involved in cases.
Right. And I think that's, what I said at the beginning is true. I think that our involvement with child support is really not well known or understood because it's a tiny piece of what we do.
Yeah.
But we are under Title 15A when it comes to termination of parental rights and adoption in the same way anyone else is as well. So most of our CHIN's work is happening under Title 33, but then that ends, the work of that statute ends at termination of parental rights, and then we pick up and use Title 15A
Okay,
in the same way anyone else
okay,
was or does who's pursuing adoption.
okay.
Other questions?
I don't,
Yeah, go
what
ahead.
is a revenue enhancement?
Well, I like to say it is an aspirational title. So this was a position created about 15 years ago, and it brought together at that time anyone within family services who had anything to do with money. And so we were overseeing grants and contracts, and we do Title 40 eligibility determinations. We look at benefits for children. And a big part of my job is actually understanding what federal funds we receive, what work is eligible for those, how we best use them, things like that.
That's good to know that exists within CF. We've talked about Title 40 and trying to maximize use of and drawing down.
So I will just give a testament to Heather's ability to enhance revenues. Because as a nonprofit provider, it was super helpful in being able to sort of funding sources and for maximum stuff. So it's a really important position, and I'm grateful you're still doing it. Thank you.
Any other questions? Yeah, Eric.
Thank you, Eric Pepper, City Council. Just want to be clear about where you think the carve out should go. Your thought on that? Like, to me, it sort of makes sense that it would be in Title 33 somewhere.
I don't have an opinion about that. I know that we have legal folks talking it over and coming up with proposed language, and it's going back and forth. So that's something we could definitely be in contact with you about where it makes the most sense.
Okay.
So we need that by tomorrow.
We are happy to provide it.
Thank you.
Yeah,
I just gotta talk to the board.
Okay, we good, Eric?
Yeah, I think so. Yeah.
All right, great. Thank you. Thank you very much for being here. All right, so we have two more witnesses and then specifically looking at H36 and ultimately deciding whether we're going to include that in 109. So we will go to Jen Collin first. Jen, thank you for being here again.
Hi,
Nice to see you again.
Nice to see you. Thank you so much. It was so fun the first time. Happy to come back.
So it's H36 and just wondering if you're good with this. You have any input on it?
Great. Thank you. Jennifer Colon, General Counsel for the Office of Professional Regulation. Thanks so much for having me. H36 is a provision that has to do with family forensic evaluations. And that's not a space that the Office of Professional Regulation really is in at all. We regulate the licensees who are presumably performing those evaluations. And if we can help the judiciary in kind of figuring out the issue of, the supply and demand problem, they don't have enough of these folks doing this kind of work. And sounds like trying to get to the bottom of why that is and how can we improve that? What are the barriers? That makes a lot of sense to us. And we heard Judge Zone a few minutes ago talk about how he thinks that there's a lot of value in doing this report. So OPR views kind of the judiciary and the judges who are going to be involved in this work as the lead on this report. But we're certainly happy to provide any kind of support that we can. It appears to me that B2 that talks about whether protections regarding ethical complaints are warranted, that seems to be the space where OPR would be most involved. As y'all know, OPR does receive complaints about licensed practitioners that we regulate. We get about 800 complaints a year, and we have a screening process. We have in-house investigators, prosecutors, administrative law officers. We have a whole kind of court system within OPR. to sort through these and adjudicate them. And so, you know, the idea of whether there should be protections for folks who are in the family forensic evaluator space, whether they should have some sort of carve out ethically from having complaints. That's an interesting question, and we're certainly happy to weigh in on that and participate in that. And something I also want to point out to the committee at this point, and I'm sure this will be more developed in the reporting process, but we don't get many complaints about family forensic evaluators. And you would think that we would. We see them occasionally when people are unhappy with the outcome. I consulted with our enforcement team and was not able to find a single instance where we prosecuted somebody for unprofessional conduct or an ethical breach because of the work that they did in this space. So when I'm thinking about barriers or things that might have a chilling effect on folks who are willing to do this, the idea of ethical complaints being filed against them I'm not sure that that's one of those barriers. However, happy to work with the judiciary and explore this question and provide any support that we can.
Any questions? Yeah.
Oh my goodness, I'm gonna run. All right, great.
All right.
Thanks so much.
Yes.
Anytime.
All right, we'll go to Linda Marshall. Thank you for you're still there with us, Linda?
I am somewhere.
All right, hey, thank you for being here. I appreciate it. If you could just identify yourself for the record, if you could just weigh in on this bill.
My name is Linda Marshall. I'm the executive director for the Vermont Psychological Association. Thank you for including me in this discussion. So, I mean, it's, excuse me, my reading of the bill is that gives a brief definition of what a family forensic evaluator is, and then creates a work group, for lack of a better word, to look at some issues around that. And I think it's always a great idea when we can provide the judiciary with extra information to help them make decisions. I think that the issue is pretty complicated about barriers and the ethical complaints, as Jen kind of mentioned, that they haven't found an ethical violation, but I think that it's a minefield of walking through. But I think it's definitely worth discussing and worth coming up with some suggestions and some recommendations to the legislature.
Are there any particular issues you have with this, or anything else you'd like to see in the bill, or are you okay with where we are now?
Well, that's hard to say. I think that there's some things that could go into a report. One thing that if under the recommendations, section 1A, if the legislature or the committee intends that to be the definition of a family forensic evaluator, I think it needs to be a little bit more refined from a clinical aspect. A family forensic evaluator, if it's a licensed a licensed mental health professional, who is their client? What are they evaluating for? What standard are we using or is there a standard other than best interest of the child, etc.?
Yeah, I would think that we're trying to keep this probably just in this bill at a higher level, and certainly if those are elements of the recommendations, that would make sense.
Absolutely.
I would assume there would be a further, more in-depth definition about what is being talked about in the recommendations. Yeah.
Yes.
I appreciate that point though, and it made me wonder if we should that be, this reads to me more like a finding, legislative finding than it seems like a pretty non-traditional subsection in a way.
So I guess the question is, do we need that provision of help?
Yeah. I'm not
I mean,
sure.
yeah, I
Either
don't-
we don't, or I think we should make it very clear that this is not an attempt to define in statute what a family forensic evaluator is.
Yeah, no, I think we just should take this out.
Yeah.
Yeah, I think, good point, because it's not really needed. The people in the group know what we're talking about and why put something in that kind of binds us with definition. That doesn't really bind us, but
Could be interpreted.
Could be interpreted, so.
And misleading.
So take out all of A.
Yeah, I'd say take out this. That makes sense. That we don't lose what we're after in here by taking away. Linda, thank you for pointing that out. And Angela, thank you for not letting me get away with this, saying, please. It takes a village. Anything else on that?
Did you make that up yourself?
I've heard it. It's some.
In the village.
Yeah, I've heard it. All right, well, thank you very much for your time. I really appreciate it. And hopefully you've had some fun watching our deliberations to the extent that you're paying attention to us earlier on all these things. So it's really helpful to have your input, though. I appreciate it.
Well, it was my pleasure. Thank you.
All right, thank you. All right, so we're going to turn to JRS 15 now. And if we have, I don't know if everybody has gone to their copy from. I know mine is probably somewhere, but.
I can put my hands on mine.
Oh, I need.
I have no.
Anybody else need a hard copy?
Manatee.
Basically, do you want them?
I'll take one after.
I would say.
I'm just curious.
I don't need one.
They're good.
They're good.
It's
JRS 15.
Yes, I've requested.
Yes.
Yeah. Okay.
So it's seaweed.
Yeah. Seaweed with crunchy stuff.
Sauce me a bag.
Hmm?
Sauce me a bag, will you?
Oh, yeah.
There's different varieties.
Ooh.
Wasabi, tom yum.
Wasabi.
Here, try that one, and if you don't like it,
Different than the one you have?
you can have this one.
That will clear your sinuses.
Spicy flavor,
I'm not seeing
hot
it.
and spicy flavor.
Must be from the seaweed.
It smells really bad when you first open it up. Ooh.
Oh, wow.
Thank you.
That's good.
This is like real manatee food.
Yeah. You know? Yeah, it just makes me think. a little.
Yes, please.
I don't remember now how thick that is. Yes.
I like that one better.
All right, you got it.
Everybody, if everybody has this, so this is a resolution, that, I guess it doesn't really celebrate our accomplishments, as legislature with respect to, trans and non-binary individuals. It's really to, I think, given the fact that, this community is one of the most vulnerable communities in Vermont, particularly the pressures coming from outside the state, that this is really to reiterate our support for this very vulnerable community, and really that we have their back. So to move this along, I'm going to go ahead and take a motion to find the resolution favorable, and then we can have further discussion. Is there a motion?
So moved.
Is there a second?
Second.
In a second. Okay. So open for discussion. Anybody want to discuss it?
We discussed it at great length.
We have discussed it, and I'm happy to go right to a vote if that's what we want. So,
We've discussed it.
yeah,
This came out of the Senate, right?
yes.
Yeah, what was the vote down there?
My understanding, the vote was unanimous on the floor of the House.
Right, Senate.
Oh, Jesus.
We know what you, don't beat yourself up too bad over that. So I would be all over the village saying no to that.
Well, seeing no discussion, clerk could call the roll. You have the paper for the roll.
It's still reading, but I guess it kind of.
Oh, okay, well, no, I,
I can
We go.
I
Yeah,
can
go ahead.
share. I'm
Yeah.
just, I'll share. enthusiastic support. I don't know why my face didn't match my words when I said that, but I'll share enthusiastic support for this resolution and express, dismay at the fact that I do think it's necessary. And I think a lot about the statistics we have regarding LGBTQ plus youth, especially in our state through the youth risk behavior survey, YRBS. And we know that young people who identify as LGBTQ plus have a higher rate of self-harm, suicidality, and all manner of mental health challenges and just challenges within culture, local cultures, family, and all kinds of potentially life altering challenges. And I really support any effort that we can make given our position to show our support, especially for kids in Vermont. But for adults as well, but I think a lot about LGBTQ plus kids and what it's like right now for them and what they're hearing in various places and seeing. Certainly try not to go down again on any sort of social media soapbox, but they're just extremely vulnerable to begin with, and any support we can provide is important.
Thank you. I don't know, good kind of give the chance to go through it. All right, let's call the roll.
Arsenal,
Yes.
Dolan,
Yes.
no,
Yes.
Center, yeah. Harvey,
No.
Oliver,
No.
Rachelson,
Yes.
Christie,
Yes.
Burdick,
Yes.
Balon.
Yes.
I know, right? What did you put for
One
her?
job.
You gave her something.
Malay,
Yes.
And so,
I make a motion that we get a new clerk.
yeah.
overthrown.
Is my name not even on there?
I was being in alphabetical order.
So Karen has agreed to report the resolution. Thank you, everybody, for this. I'm glad that we are moving this one along, and hopefully we'll have a couple more votes this week. Still working on some language for S87, the extradition. Kim McManus is going to maybe take a shot at some language to address some issues that Tom and I were talking about earlier today. S44, we'll see what happens with tomorrow's H511, which is a short form bill, has to do with immigration, access to schools. Don't know that that's something that we're going to be able to do, but we're going to take that up tomorrow morning. And if we do, and if it does look like it's something that should be done, we can put it on 44. But 109, I'm really shooting to about this Friday, because that's a bill that's going to be going back and forth. It's going to go to the Senate, and they're going to probably put more things on it and come back to us. So we need to kind of get it on. We're starting to do calendar math, where we're running out of time. Believe it or not, right? But good, or that we're running out of time. So any events, only for 4 weeks, maybe. 5.
Do we have updated copy on 511?
So I am going to have posted, so 511 is just a short form, but there's language that Will has been working with me and with Rick, and I will get that posted, or I can email it out to folks.
Can you just send it to the, I was in the
I'll
impression
send
that
it.
something was coming.
Yeah, I will send it to everybody, and it will be posted tomorrow for folks. I know that I asked Nate to send it out to witnesses, but it should go out to all of us as well. So yeah, I'll get that out to everybody. Let's see what else is there going on. So on 109, I want to talk to Eric, in fact, shortly, just to to go over the stuff that we've talked about, and I guess a couple questions for the committee. Are we good with the S36, the H36 that we just heard about, putting that on? I mean, I don't think anybody was opposed to that. I think the biggest changes were with respect to the sentence taking reconsideration working group. And I think I captured a lot of where we may need to make some changes. The biggest one that I want to just run by folks, and we can discuss this a little bit further. If you're looking at 109, I'm looking at page 34, and I'm looking at line 10. And that's, the viability of a second look review process. And my concern there is that I've been looking at this for 5 or 6 years, and I mentioned it already. It's like we can't get consensus in front of, when we have people testifying. So we send it to a study group or we send it to the sentencing commission. And they again can't reach consensus because people are set where they are. So I don't like the idea of just saying the viability of a second look review process, because that's just asking for more of the same. But on the other hand, if we like make the presumption that we're doing it, we're not going to get support from the Department of State's attorneys. So I suggested some language, and it will have to be tweaked when I talk to Kim offline, of something along the lines of how sentencing reconsideration could work in Vermont and in relationship with other post-conviction remedies. So that's kind of a little bit more than just check out the viability. It's like, how can you make this work? I'm not telling you that we're definitely doing this. I'm going to have Eric finesse that language, but are people fine with that kind of splitting that, trying to find something between where the Defender General is and where I understand BSAS is? That
Not only do I agree with it, but it seems like that's our job. Land somewhere in the middle between deck and.
True. Yeah, we tried to do that. That's true. I think the other things, I guess I mainly want to understand from Tom, if I wasn't listening. Yeah, I'll work with the language and find you for that. Because this comes from Tom's bill.
Right now.
Well, Eric McGuire's bill and Eric and Tom.
Yeah.
So I'll make sure, I'll talk to you after.
I think that did just prompt one question for me. So do these committees, they need to be unanimous when they come back to us on?
They don't, but it's like, well, no, they don't. But when we send it to like the sentencing commission, we want them to come back and then we see that their vote is split. And we really were hoping they would come up with something that it's not the courts and the Defender General on one side and the state's attorneys on the other, which it has been on this issue for the past 5 years.
Okay.
So we're trying to push them along.
Yeah.
Because I think there is a way they can get there. I don't know what it is. They suggest.
Probably a very, very small.
Yeah. Maybe see what it is.
I mean,
We do.
your point, I think like that is our job to implement. Sometimes.
Yeah, sometimes we have.
Sometimes when we can't get to that place, that we are in a position to make a decision to say, well, we're going with this.
That's why it's kind of, I'm also just saying, how can we get?
Yeah, I like that. If we were to do this, how would it?
Or you
how
go to
would
a
it-
study committee.
Yeah, yes. So are there any more stuff we want to throw in here? We only have 4.
How about
I have a question on that, actually.
Yeah.
So one of the earlier ones, I think this was the gun committee.
Yeah.
There was the compensation reimbursement clause, and so on
Yes.
page 19.
Yes, which
But we did not include that in this most recent one. So I'm wondering,
So so the reason we put it back in that one is that the FFL is not being paid. They're like all the
Right.
other people. So it's the FFL that caused us to say, now we need to put the compensation one in there. And in the last one, everybody is already compensated. They're all government people.
is it Lopez?
What's that?
GWAP? Did anyone?
But we're taking
them out.
Talking about swapping FFL with Chris Bradley.
No, just it was either going to be the FFL or Chris Bradley,
Right.
and either of them would be entitled to a person.
I just thought we had agreed that that wasn't going in.
Yeah, no, it wasn't until we put FFL.
Okay.
I know Chris is okay with the swap.
No, that's not my.
No, I know.
It was
what you're
just
saying.
the money, it didn't have,
Yeah,
it didn't
yeah.
have
My point
compensation.
is the compensation.
So,
So I wondered, because sometimes we forget about the crime victim services folks, if they, on the sentencing. We added the network, but then I
Oh, no, I
wonder,
thought.
They're-
They're in there.
they are, okay, I'm sorry, I missed them.
I think they should have a double vote.
Yeah, really.
When you put the network in.
Right, yeah, you're right.
All right, well, thank you, everybody.
Guys,
Yeah.
sorry, one other question. So Judge Zone kind of testified that he didn't think that the 2-year sunset was necessary on the 80 hours thing. And we just hadn't talked about it since he testified. And just because I've had to do the work to, I just want to know, do we still want the 2-year sunset and the language on the report or not?
I'm fine with having a 2-year sunset. Still, I mean, I think it doesn't hurt anything. I don't know that we need to have a report because I think we'll have them coming in. From what I was hearing is it's going to be more of them coming in and saying more anecdotal a little bit
Right.
than having deep data. So I don't think you need to do it,
And just because we didn't have Ben here to talk about it, and I didn't want to testify while we were taking testimony, we looked at a bunch of different jurisdictions and the hours that they do for community service for DUI2s, trying to find ones that kind of match up with Vermont. It's not a perfect way. There's no perfect way to match them up because there's a lot of different ones. The 80 hours is based on Oregon's. So it's not just like a totally random number, but there were a lot of different ones and some of them had different criminal, like low numbers, like it was all varying.
Did you say one state has 24 hours in jail?
Yep.
And then like 60 hours at community?
Yeah, so some went lower on the jail, higher on the jail. Some had ranges, so capped the max that you could do for the community service. Where here we wouldn't be doing that. We'd say you could do 80 minimum, but you could do as much as you wanted on the other end. So I just didn't want to testify about that while we were doing questioning, but so okay, I will go. So 2-year sunset, no report.
Yeah, I
And
just
what's
from
sunset
what the
gonna be based
testimony
on?
was as far as what kind of information they're going to have. I don't know.
Great.
But
Check in.
what will happen is people will be like, oh, there's a sunset, whoa, I like when things are
We'll be able to make a
based.
data-driven decision at that point, I guess.
Yeah, that's kind of like, yeah.
Is
We
that-
don't have a sunset. And if we have no information if it's working or not, this thing doesn't get looked at again for another 10, 15, 20 years. So it happens to come up.
So I kind of like, I mean, so one can either have data and get a report back, and then we look at the report and decide if we want to do something about the bill, or we force ourselves to look at it with a sunset. I don't think with a sunset, you necessarily have to have data. It's like, I mean,
Makes
you
sense.
don't have a report. I mean, it's something to react to. Yeah, we can react to reports, but from what I heard, they don't really have data. Or we can react to the fact that it's going to go away in a sunset.
So if I can offer a thought, sunsetting at 2 years, there are people who will be on probation for 2 years on a DUI2 who will have like this 80 hours if we change it. And with the sunset at 2 years, there's like a little bit of a, I think we could write in language that it wouldn't impact people who are already on probation on the DUI2 with this, but it makes it a little more complicated. If we did a study that came back to us in 2 years or in 3 or whatever you wanted, and then we could look at it, it wouldn't have any impact on people who are like actively on probation for DUI2s on this.
Are you saying we need a longer sunset or we need a report?
I'm saying that we can do either, and it's whatever you guys want to do. If you do 2-year sunset, then you're going to have people running up against their probation term when the sunset is happening.
Right.
So either a later
Sunset work? Yeah. So we do 3 year?
Great.
Do we need to still see DOC? Do we need to have them back in? I mean, we had them in before. It's just that I had a note to myself on whether we need to bring them in. So the only additional testimony that I think I had down was Marshall Paul on this section.
Yeah.
And I may just ask him if he's fine with it to just email, so we may not have anything further. But we will look at the additional language and I will, rather than bringing everybody in, I'll probably send it out and ask them to get back to us if they want to weigh in further.
It really doesn't change anything as far as people's testimony.
Right, right there. Yeah, so.
Can I ask you
Yeah.
a question just to make sure well, so you're confident, are you confident that, are you confident in based on experience as you term is when you, write in a sunset? And I hear you saying that we don't need a report because we'll be getting testimony and we'll be, because the sunset, it forces us to take a look at it. But are you confident that the entities involved will have been collecting the data we need to make a decision at that point? Like, based on our conversations, present day, will that be enough so that, because
Right.
is that enough? Or do we need to say, as Kim suggests, did Kim suggest to say, wrote it down somewhere to kind of direct them to keep specific data?
I just sort of,
Presumably,
well, I mean, I guess I took it more from Judge Zonate. Kind of saying that they would have an idea that some people have taken it or are more apt to take it. And he kind of, it was like, he was kind of pushing back as far as, is there really data that? I mean, that's great, if you think we should have a data element in there.
I guess I don't know for sure. What we've heard in testimony makes me unsure. I get the sense that the data we'd be looking for is not currently being kept, and I think it's actually difficult to ascertain, to actually obtain the data, because we don't ask a person when given the choice, we don't then follow up with, and why are you choosing this? Doesn't have anything to do with the 200 hours, so. We will have a baseline.
Should explore with our people a little bit, just to see what kind of data.
Well, we wouldn't have, what's our baseline?
Could
What would we compare?
So
They're not gonna get rid of the data, right? So the data is gonna be how many DUI twos pled out in the last 3 years? Did they plead to the 60 hours minimum going to jail, or did they plead out to the 80 hours of community service? Or did the judges?
Sentence.
Oh, yeah, it just, no.
They never get, this doesn't get sentenced.
Yeah, and that was kind of what I was trying to elicit from testimony, is that like, yeah, I guess if you go in front of the judge, you're gonna do like one or the other. But a lot, like with the plea agreements, like the prosecutor and the defense attorney are working together to make an agreement. And the prosecutor can say, I'm not going to agree in a plea agreement to the community service.
Right.
I'm only gonna offer you the jail time.
But the plea agreements are entered in the sentence. I mean.
Oh, yeah,
you know what
absolutely.
that is.
Yeah.
So, I mean, what I was kind of thinking is that in a couple of years, we would ask CRG to do a report that tells us how that is working, as opposed, because the data is there. The data is in the sentencing. They would look up all the DUIs, the DUI twos, and they would look at what the sentences are, and they would give us some statistics on it. So I would think.
We just won't know if it's causation or.
Well, that's the thing that Judge Zoning said, you're not gonna be able to.
Yeah.
Get at that. That's the thing. We're gonna be, the raw numbers, I think, are accessible to us. But the motivation is going to have to be what defenders and prosecutors and judges tell us about their experience.
But if, depending on the timing, and the window that's observed, if you're evaluating a point in time and comparing it to that 2-year span of time, you will be able to make some assumptions based on that.
Yeah.
Because you should see patterns with the numbers that they're talking about, and we don't see any major changes coming with people's drinking habits. So that being said,
And that would be the other thing, pretty interesting to know if it actually impacts other people. Oh, yeah, it's something else. Yeah.
Judges don't like minimums at all. I would just say put a maximum on and let it work out. Sentence, because they're gonna make some.
Yeah, Judge has suggested that put in the minimum. Well, we would drop the minimum at least, because right now.
Well, he was just like, we can go higher.
Yeah.
Yeah, they can do whatever they want. They're gonna do what they want generally, unless we stamp it with a minimum. But I mean, I think they're big enough when both sides are negotiating, you come up with what the sentence is gonna be. You just put a max on it, say not more than this community service hours, not much more than this incarcerated. And they'll fall on something,
Is this a situation
because every situation is gonna be different too.
where a minimum is gonna go with plea deals like we've heard before?
Well, I guess it's just that we're improving the situation significantly, moving from a 200 minimum to 80. And
Right.
if we want to get rid of all of it, I don't know that.
But what it rules out, it kind of lets the person actually decide what's gonna work best for them too,
Right.
like we heard.
Yeah.
When they can come up with something.
And I think that we're giving prosecutors and judges more room to negotiate by dropping the minimum, because that could let them make an agreement at 100 hours, or make an agreement at 150, or make an agreement at 75, or not 75, 85. So I think the only question I have is, do we need to ask CRG how many years they need before the sunset, so that they can give us
I think it's looking at who's
okay.
doing it, who's taking that sentence.
Yeah.
They would see the sentence. I mean, are we also looking for them to successfully complete that? Is that part of our question?
No, I don't think so.
So, I think once it goes into effect.
Okay. So 3-year sunset, no study.
I
wanna
was
push back on
asking-
that?
No, I'm actually not pushing back on a study, but if there's a way to
Rationale.
specify data collection without asking for a study.
And they have the data. I mean, the thing is, they're not gonna
We
be
are
able to get the
bad at data.
motivational.
We are bad at data in this
That-
state.
And even
In
when
the
we have it, we don't
judiciary,
look at it.
or
It
in
depends
the
on which data
in
you're.
criminal
looking
justice data, we're not that great.
for. But if you're looking at the sentence or DUI twos, and we look at the previous 3 years from
right.
now,
Like
and
a
how
recidivism
many
data.
people were.
Just remember what data you asked for the previous time, Steve.
That's him. He's the one going like recidivism, and him. They're the two.
All right.
I'd
But the
be
data's terrible.
talking all day.
Yeah, I don't think I've understood at any point that they don't retain data around just sentences. Like that
Right,
seems like they
right.
keep that. I mean, that's really
You have
all,
the very basic
Yeah.
information.
yeah, which would just be what they, yeah.
Will allow us to make a somewhat informed decision rather than a robustly informed decision.
I think.
Well discussed.
Tomorrow at 9 o'clock, so people can be in line for ice cream.